Congress leader Rahul Gandhi has been disqualified from the Lok Sabha recently. About disqualification of Member of Parliaments. Constitutional provisions. The provision for disqualification is given in Article 102 of the Constitution. It specifies that a person shall be disqualified for contesting elections and being a Member of Parliament under certain conditions. If he holds any office of profit under the union or state government, except that of a minister or any other office exempted by Parliament. If he is of unsound mind and stands so declared by a court. If he is an undischarged insolvent. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. If he is so disqualified under any law made by Parliament. Article 102 also authorizes Parliament to make laws determining conditions of disqualifications. There are analogous provisions for members of state legislatures. Defection under the Representation of the People Act, 1951. Disqualification on imprisonment. The Representation of the People Act, 1951 provides that a person will be disqualified if convicted and sentenced to imprisonment for 2 years or more. The person is disqualified for the period of imprisonment and a further 6 years. Exception for sitting members. They have been provided a period of 3 months from the date of conviction to appeal. The disqualification will not be applicable until the appeal is decided. About disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified from being a Member of Parliament if he is so disqualified on the ground of defection under the provisions of the 10th Schedule. Important Supreme Court judgments. Union of India, UOI, versus Association for Democratic Reforms, 2002. The SC held that every candidate, contesting an election to the Parliament, state legislatures, or municipal corporation, has to declare their criminal records, financial records, and educational qualifications along with their nomination paper. Ramesh Dalal versus Union of India, 2005. The SC held that a sitting MP or MLA shall also be subject to disqualification from contesting elections if he is convicted and sentenced to not less than 2 years of imprisonment by a court of law. Lily Thomas versus Union of India, 2013. The SC held that Section 8(4) of the Representation of the People Act, 1951 is unconstitutional, which allows MPs and MLAs who are convicted to continue in office till an appeal against such conviction is disposed of. The court held that MP, MLA convicted for 2 years or above would be disqualified immediately. Krishnamurthy vs. Shivakumar and Oz, 2015. The SC held that disclosure of criminal antecedents, especially heinous crimes, of a candidate at the time of filing of nomination paper as mandated by law was a categorically imperative.